There are numerous arguments both for and against the use of juries for trial. And I've been fortunate enough to watch some debate just recently, so I thought I'd follow this up with a video on some of these thoughts. Now, some of these things might appear at first blush to be a positive in favour of a jury trial. But there's also a different way of looking at it that might actually make that a negative. But likewise, talking about the judges, there might be what might, on the face of it, be a positive about having just a judge hear the case. But then conversely, the same argument might be used, but seen from a different perspective, to show that, in fact, it might be better not to have just a judge hear this trial. So I'm going to give you a few of these examples in this video, and perhaps you can let me know your thoughts in the comment section below, because lots of people have different views on whether a jury trial is the right way to proceed for criminal trials, and whether it should be replaced by a sole or panel of judges. Now, just to give you an overview of the workings of the legal system as it stands, all criminal trials will start their life at the magistrate's court. Whether or not it's ultimately heard at the magistrate's court, even indictable-only cases will start their life at the magistrate's court. Albeit, if it's indictable only, then no plea is going to be taken and it's going to go straight to the Crown Court for the PTPH, the plea and trial preparation hearing. But otherwise, all criminal cases will start at the magistrate's court. If a case is summary only, then that's only going to be heard at the magistrate's court. If it's an either way offence, that means it could be heard at the magistrate's or it could be heard at the Crown Court. Only the Crown Court, of course, has a jury. And if a case is either way, then it depends on two things. The magistrate's court may decide that it has jurisdiction to hear the case, meaning that generally its sentencing powers will be sufficient and the case is not too complex for the magistrate's court to hear. If that being the case and they accept jurisdiction, then the case could be tried at the magistrate's court. But again, if it's an either way case, then the defendant can elect Crown Court trial in place of the magistrates hearing it. So they get a jury trial instead of just the magistrates. Now, there are one or two obscure offences that sort of slip around these rules a little bit. Just one example of those without going into too much technical detail. One of the examples is a low-value shoplifting, which is under £200 worth of theft from a shop or stall. So low-value shoplifting is ordinarily treated as a summary-only matter, which means it's ordinarily going to be assumed that it will be heard at the magistrate's court, meaning that they should automatically accept jurisdiction. However, the obscurity is that because it is a dishonesty offence of theft, and theft is still an indictable offence, the defendant still gets to elect jury trial at the Crown Court if that's the case. So, with that in mind, just briefly dealing on civil trials as well. All civil trials, except for a few exceptions, are going to be heard by a judge of various levels, either a deputy district judge, which hold the same powers, circuit judge, and then high court judges and so on. However, there are some, again, very narrow exceptions. For example, defamation cases, automatically and ordinarily it's going to be a judge, but the court does, by the negative reference to a jury trial, have the power to order a jury trial in defamation cases. And of course, inquests are heard by a jury as well. That's the investigation into how somebody died when it's not clear, or as to who's to blame and who should be or should not be at fault for somebody dying. So with that all in mind, let's look at a few of these pros versus cons of using a jury, whether we should use a jury, and how some of these might be thought about. Now, one of them that is often referred to is that a jury is a somewhat easier audience than a judge, in that they are more likely to apply emotions to the case, where a judge is less likely to apply emotions to the case. Now, again, as I say, this could have pros and cons depending on how you look at it. Now, as I say, this could have pros and cons depending on the way that you look at it. One argument might be that if the jury is more likely to use emotion in their deliberations, then it might be more representative of society, taking the emotions of society into account, and therefore, as a defense counsel, you are able to play on the jury's emotions in order to bring the case some sort of realism and see the case through society's eyes and determine whether or not that defendant should be guilty and therefore should be punished. That's one way of saying that it's a positive, that cases should be heard by a jury. The counter-argument to that might be that, in fact, juries should not be trying cases with their emotions, because perhaps the emotions are absolutely irrelevant. Whether they're upset by a certain case and don't feel emotionally that a certain defendant should be found guilty of that offence, that's actually possibly a negative, because in fact the jurors take an oath to swear the case sincerely and faithfully only according to the evidence, and in fact they can be held in contempt of court if they are found not to do so. Much like there are several other offences that jurors can commit, such as sharing information and researching the case, and so on. In fact, one very interesting subject that comes up frequently is referred to as jury nullification. That is where a juror decides the case because they feel that it's morally wrong, as against deciding it on the evidence. Make no mistake, that is likely to come within the definition of what is considered to be conduct which is prohibited, because it's not trying the case in accordance with the evidence. So one might therefore argue that, in fact, because jurors might be applying their emotions to a case, that they are not trying the case faithfully and sincerely in accordance with the evidence. So very quickly you can see that the issue of emotions at play with the jurors when deliberating a case could be both a good and a bad thing, and this is one thing that is often debated. Another argument is that judges are going to be unbiased, or at least they are very much more likely to be unbiased than a jury. Some people believe that some judges are biased. I, for one, don't agree with that sentiment, but that's not to say that it doesn't and can't happen. But many people may hold that view. So on the one hand, judges being unbiased, therefore trying a case purely according to the evidence and according to the law, if the judge were hearing the case, then the judge is without any such bias. But the counter-argument to that some people make is akin to emotions, not bias as such, but without the influence of one's experiences, which some people describe as bias, when thinking of that along the lines of the jury should be representative of a society and its collective experience and emotions and views. One might chalk that up to be some kind of bias, as in they are biased potentially by their experiences, and their experiences ultimately culminate in some kind of bias. So stripping away all of that bias is essentially stripping away all of that which the society, the representative society of which the jury is made up, might then mean that it loses that very essence that the jury is representing, that essence and collective experience of society. One of the very obvious arguments that is made is that judges will understand the law. Now, this is a clear argument in favour of judges hearing a case only as against a jury, because the judges understand the law. They are obviously very well trained and very experienced in the law, and will know as a very clear-cut argument whether or not somebody has broken the law and therefore should be punished for it. The counter-argument for that is that if that is potentially too strict, and there is often described as a line between the law and humanity, and that's where the jury sits, as it's often put. So is it in fact the case that a judge understanding the law to the letter is perhaps too strict and loses again the sight of that human input and that collective experience of society to put the case in the correct place, and not necessarily applying the strict letter of the law? Although, again, coming back to the jury oath, this is what the jury are supposed to do. They are supposed to try the case sincerely and faithfully, solemnly, only according to the evidence and on the judge's directions as regards to the law. Similarly, you might also argue that with the judge simplifying and explaining the law in demystified terms, it might be easier for a jury member to decide the case according to the evidence, but with a simple direction as to what the law is. The judge will put into simple terms, for argument's sake, talking about self-defense. The judge might say, you need to consider whether or not this defendant really believed it was necessary to use force in those circumstances, and whether or not the defendant really believed that he was in danger at that moment in time. If that's the case, then you must go on to think about the use of force and whether that was a reasonable and proportionate amount of force in those circumstances. So the judge will explain this in terms that the jury can understand. So perhaps understanding the letter of the law is not necessarily so important after all, but perhaps it might be more important for the counter-argument that a jury consider more the human element and the evidence without getting bogged down into the understanding of the letter of the law and instead have it explained very simply by a judge. Another clear argument is that jury trials are taking much longer than it would if it's just with a judge. This is often represented with civil cases, which can be over in a fraction of the time of criminal cases, largely because a judge knows exactly what the issues are in the case and gets much more to the point very much more quickly. And as a standard rule, witness statements in a civil trial will make up the primary evidence of each witness, unless of course there is a need to extend that evidence, in which case the judge will provide permission. But the reverse is true in criminal trials. Ordinarily, witnesses will be giving their evidence live, unless of course the statements are agreed. But if the statements are agreed, it's usually not a pivotal point in the case, in that it's not going to be something that the prosecutor and the defense counsel disagree upon. It's going to be something that is just an agreed statement, usually a set of facts, and potentially only part of it will come to live evidence. So on the one hand, it's a very clear argument to have a judge hear the trial instead of a jury, because it takes much less time. The counter-argument to that is, do we really want to be rushing through the courts these criminal trials heard by a judge only, one after another? Because after all, it is a criminal liability and punishment that follows. Do we really want to get into a position where these courts are hearing case after case and deciding the criminal outcome and appropriate punishment? Anyone who's ever been to a magistrate's court, but particularly if you're pursuing a career in law and you see the speed at which these cases progress through the magistrate's court, you might get a sense that this is far too quick for real criminal justice. There are a couple of good books that talk about this very thing, one of which called The Secret Barrister. I will link that in the description below. And for the avoidance of doubt, I am not the secret barrister, although I have been questioned about being the secret barrister before now. I am not. He or she is a brilliant author, and the book is linked in the description below. I suggest you read that book if you want a further understanding of all of the issues that I'm talking about in this video. Another argument is that the judge knows all the evidence and therefore has everything before him or her with which to decide the case. Clear argument, you might think, in favour of just a judge hearing the case, because how can one possibly understand and therefore decide a case without having all of the evidence laid out before you? Therefore, let the judge hear the case, you might argue. Conversely, let me talk about why some evidence might not be given to a jury, and therefore why it may not be a good idea for just a judge to hear the case. Now, some evidence is ruled to be inadmissible for a jury to hear, so the jury never hear that evidence. One example is previous convictions. If a defendant comes to court on, let's say, an offence against the person charge, but let's say they also have a previous conviction which is drug related or perhaps dangerous driving related or something else which is not related to the current charge, then those will not come to the attention of the jury unless, of course, there's a successful bad character application or there's a bad character argument made against a prosecution witness, and therefore it's fair game to bring out the previous convictions of said defendant. But otherwise, in the normal course of things, the jury is not going to hear about these previous convictions. Therefore, they are much more likely to try the case only on the evidence that's heard in court. Whereas the judge, of course, is going to have the previous convictions because the judge would always have access to the previous convictions, because ordinarily it's the judge that's going to rule them to be admissible or not as the case progresses. The same goes for various other bits of argument and evidence, because if something is deemed to be hearsay, and unreliable hearsay, and it doesn't get admitted under one of the various rules, then the jury is not going to hear that hearsay evidence because it's generally held to be less reliable. So if the jury doesn't hear that less reliable evidence that they could otherwise be swayed upon, then they are more likely to try the case much more fairly according to the evidence that is deemed to be suitable for the jury to hear. So let's say, for argument's sake, there's a piece of hearsay evidence which is very unreliable, but if heard would very much convince the jury that this is the truth of the matter and therefore the defendant is guilty. Then obviously the jury is more likely to convict that defendant if they hear the evidence. But if the evidence is not reliable, then they shouldn't be hearing it. But the judge is going to hear that evidence. Now, it's a common law school debate as to a magistrate hearing the evidence and ruling on it as to whether it's admissible or not, and then making a decision and a verdict in the trial, ignoring the inadmissible evidence. The argument is, of course, well, surely they must be swayed to some degree because they've already heard the evidence and they already know the content of the hearsay or whatever it might be. And therefore, many people argue that surely they are persuaded somehow, at least to some degree, to come to a guilty verdict as against not guilty. Now, we would all like to think that all magistrates and judges and magistrates in appeals to the Crown Court are going to try cases and not consider the inadmissible evidence, but nonetheless, that is one argument that many people make for and against having a trial just with a judge. And finally, just something to leave you to think about, although I'll come back to in much more detail in another video because it deserves its own video, is the concept of jury nullification, which I've referred to before. Now, make no mistake, a lawyer referring to this in court would be contempt of court, and a jury member carrying out what's referred to as nullification would also be contempt of court because it would not be trying the case faithfully in accordance with their oath, which is a promise to the court to try the case only on the evidence before them. But nonetheless, the argument is that some jurors are just going to come to a verdict based on what they personally believe and not the evidence. Now, of course, this is an argument that falls both ways as well. Some people believe that that's a good thing because they should trust in the humanity of the collective minds of the jury, and conversely, that's a bad thing because it really should be tried just on the evidence. And of course, we would expect a judge not to come to a verdict in that way, i.e. the judge would be trying the case in accordance with the evidence. Now, as I said, many people have different views on everything that I've just said. Those views are perfectly fine for you to leave in the comment section below because there are different views about all of these things. But of course, there are warnings that come with being on a jury. You do swear an oath being on the jury, and it is possible to be held in contempt of court for things that you do whilst serving on a jury. The case of the Attorney General and Dallas is one example where there was a 6-month prison sentence resulting in a trial against said juror for contempt of court whilst serving on the jury. So make sure you subscribe to receive that next video and my thoughts on exactly that issue, which lots of people have asked me to do for probably 2 years now. So make sure you like this video and subscribe if you want to hear that one. And in the meantime, thank you for watching.